Bias's death sparked a national media frenzy that was largely focused on the drug that many people mistakenly believed killed him, crack cocaine. Um, During the months leading up to the 1986 midterm elections, there were over 1,000 articles in the national press dealing with crack cocaine, and even in the congressional records, specifically identifying and combining crack cocaine with race. It was not too long after the death of Len Bias, actually within a matter of weeks, that Congress passed the Anti-Drug Abuse Act of 1986, which differentiated between crack and powder cocaine and the establishment of mandatory minimum sentences. For example, 5 grams of crack cocaine, the weight of a couple of sugar packets, shall we say, carried a mandatory minimum sentence of 5 years in prison, in federal prison, whereas it took 500 grams of powdered cocaine, 100 times the amount of crack cocaine, to receive that same 5-year sentence. That became commonly known as the 100-to-1 quantity ratio. Many people say, well, you know, more blacks use crack than whites. I know originally, based on media sensationalism, I in fact thought that that was the situation. However, the National Institute on Drug Abuse, NIDA, conducted a variety of various different household studies which showed that that simply was not correct. It showed that whites not only use cocaine more so than blacks, but use specifically crack cocaine more so than blacks. So then the question goes to, why is it that blacks are so disproportionately, or were so disproportionately impacted by this 100-to-1 ratio between crack and powder cocaine? Primarily as a result of the manner in which law enforcement has been deployed to primarily people of color communities. If there are more policing going on in specific communities, inner city communities, then more people are more likely to be arrested from those communities, to be convicted from those communities, to be sentenced from those communities. And the sentences themselves, while facially neutral, have a racially discriminatory impact. So there was a clear correlation between the media sensationalism that was going on at that time, sparked by the death of Len Bias, and the whole tougher than thou climate that was going on in this country at that time, where there really wasn't much difference between Democrats or Republicans, white politicians or black politicians, conservatives and liberals, etc. Everyone wanted to make sure that they were tough on crime. Many of the comments during the past number of decades had come up, well, it was the Congressional Black Caucus that was calling for some of these strict and tough laws. I think what we really saw, Lisa, was the law of unintended consequences, shall we say. Everyone wants communities to be safe and to be protected, but no one really wants laws that are not fair. And that is basically what came as a result of the disparity in penalty between crack and powder cocaine, what was engendered as part of the Drug Abuse Act. And I might add, in 1988, 2 years later, Congress went a step further and for the first time differentiated simple possession of one drug, crack cocaine, for a mandatory minimum felony sentence. Up to that time, simple possession of any and every drug was a misdemeanor, not a felony. But in 88, it was extended to crack cocaine. And also in 88, it was extended to issues of conspiracy, which brought more and more people within the ambit of these long, harsh, mandatory minimum sentences, leading to what we call the girlfriend problem, which, again, brought the lowest level players in the drug field to be able to be subject to these long and harsh and unwarranted and egregiously severe mandatory minimum sentences in general, and for crack cocaine in particular.
And tell us, since 1986 and 1988, What's happened subsequent to that in terms of the laws?
Well, there's been a lot that's happened since that time, but we're talking about over a period of nearly a quarter of a century, actually. Okay, so while there have been many advances, and I'm going to talk about them right now, that have occurred, it was over a very, very lengthy period of time, and it's still ongoing today. The United States Sentencing Commission back in actually 1995 specifically looked at this issue and really voted to equalize the penalties between crack and powder cocaine. That recommendation was summarily rejected by Congress. In fact, they said it was the first time that Congress rejected the recommendation from its own body of experts, the Sentencing Commission. I just want to give another little background, if I can. All of this came on the heels of the 1994 federal crime bill. This was a crime bill that saw the largest expansion of the death penalty in modern times, a crime bill which saw the evisceration of the exclusionary rule for the restrictions on habeas corpus, the crime bill which instituted the charging of 13-year-olds as adults, which engineered the federal three strikes law, the same crime bill which refused to address the issue of the disparity between crack and powder cocaine, and the crime bill which gave loads and loads and loads of money to states to build more and more prisons to keep people in there for longer and longer periods of time. And as Karen mentioned earlier, this was the same period of time which we saw the escalation of the militarization of police forces and people of color communities, largely as a result of the war on drugs. So fast forward to 2010, if I might, the Fair Sentencing Act was passed by Congress again after nearly a quarter of a century of people seeking to have the disparity between crack and powder cocaine eliminated. The Fair Sentencing Act reduced the 100-to-1 ratio between crack and powder cocaine from the egregious 100-to-1 ratio to a more reasonable, although still insufficient, 18-to-1 ratio. But it was significant since the disparity had been going on for so very long. It was the result of bipartisan coalition and efforts on the Hill and outside of the Hill as well. But what happened was that it left a large number of people not impacted by the change in the law because the law was not retroactive. The United States Sentencing Commission adjusted its federal sentencing guidelines to make their guidelines retroactive with respect to the crack versus powder cocaine. But that did not have an impact on the mandatory minimum sentences. The Supreme Court also looked at the situation and said, we need uniformity in sentencing, and those whose cases occurred before the Fair Sentencing Act passed but had not yet been sentenced should still be able to have the benefit of the act. So there were significant advances during that time period, several years ago. But we still remain with the situation where the Fair Sentencing Act, which reduced the disparity between crack and powder cocaine from 100-to-1 to 18-to-1, is still not retroactive. There are scores upon scores of people still languishing in prison. These are the same people whose very egregious sentences inspired the passage of the reform bill in the first place.
It sounds like the war on drugs is a money-making business. So you have a lot of police departments, law enforcement, prisons, people making a lot of money on the war on drugs, and it's affected the mentality of law enforcement and police departments, obviously, in terms of this militarization. So how does the sentencing reform that we now see impact this mentality in terms of militarization, and how do you expect these police departments to give up this money and all the things that they've benefited from the war on drugs?
Well, one of the problems is the system of skewed incentives, shall we say, that really incentivize law enforcement to stop more people, arrest more people, and thereby, them becoming convicted and incarcerated at exceedingly high rates. We need to do something with these incentives. When I spoke about the crime bill in 1994, it was one of the major architectures, shall we say, of these skewed incentives, giving states money if they adjusted their sentencing laws, i.e. what is called truth in sentencing, which basically really took away the ability for people to be released early on their sentence. They had to serve a specific amount of time. And so it's like a circle or cyclical type of scenario. And the only way really to break free of it is for policymakers really to look at what's going on and seek to make reforms, which is beginning to happen right now.
Well, when you talk about reform and policymakers, obviously the Attorney General Holder has implemented reforms such as limiting the use of mandatory minimums and a project to study data on searches, arrests, and case outcomes to determine whether bias exists and what's the impact of that bias. Do you think that these will be helpful in stemming the flow of minority communities and the impact of prison?
Oh, absolutely. Attorney General Holder has called mass incarceration a moral and an economic failure. And the measures that he's taken to seek to combat this over-sentencing and what we're really seeing as the norm in sentencing as opposed to exception, the measures that he's taken has really been huge. This really is the first time I think that an attorney general has called for such massive reforms on such a massive basis, particularly in the realm of criminal justice. In the past, criminal justice was something that you kind of slipped under the rug, and no one wanted to mention it because it definitely would not get anybody any votes. Well, this attorney general has taken the bull by the horns and really sought to institute things that will really change, hopefully for the long run, just how things occur. He's issued guidance to his prosecutors in terms of charging, and we don't need to continue to go after the low-hanging fruit, the low-level nonviolent offenders. We need to put our focus on the major drug traffickers who are bringing the drugs into the country. The federal law enforcement resources should not be spent on these what we call penny ante, crack cases. Law enforcement resources, federal law enforcement resources, need to be reserved for other things. The states are well equipped to handle these things, which is again one of the reasons why in more recent years there's been a lot of bipartisan appeal to criminal justice reform, which has enabled more cover for politicians and policymakers to, shall we say, do the right thing.
When you talk about do the right thing, though, how do you reach this agreement between law enforcement, prosecutors, police communities, and this whole militarization effect? How do you reach an agreement since they've been complicit in terms of this mass incarceration and kind of turning this back and turning back this mentality?
Yeah, well, they've been complicit, but I think it is really a matter of seeing that much of this has been systemic. Okay, I mean, I can sit here and say conspiracy theory, it's intentional, the war on drugs, and, in some settings I might, in fact, say that. But by and large, it is also systemic. I recall a training video, this was during the 80s, where the Philadelphia DA at that time issued a training video on how to pick juries. Okay, and what was very interesting is that, he was saying, well, you don't want black women on the jury. They can tend to be sympathetic. You want possibly, if you're going to have blacks, old black men, particularly those from the South. They're a little bit more accommodating. He says you don't want to pick people who are really smart or people who know the Constitution. You don't really want people who want to follow the law. This was in training. So when I say that a lot of these policies and practices are structural or institutionalized, regardless of the specific thinkings of individual prosecutors or young rookie prosecutors, they are required to go by the book. And the book is the way in which they have been trained. So I think the Attorney General is beginning or trying to break through all of that, and to begin reorienting thinking so that mass incarceration, over sentencing is not the norm, that we're not comfortable with 5 years, 10 years, 15 years, 20 years just being meted out as the normal course of business, but that those should rather, in fact, be the exception. We do not need to continue using the militarized metaphor of war when we're dealing with domestic drug issues. We should more so be looking at the public health field when we're looking at those issues, and all of these are part and parcel of what the Attorney General is doing. Can I mention something about commutations?
Absolutely.
Is that okay? This is a more recent initiative, and again, it is an initiative that seeks to undo some of the harms that have come about over the past several decades. Many of the laws have changed. The crack law changed. There was laws that have said that judges can't make certain decisions. It has to go through a jury. But there are many, many people languishing in prison as a result of those laws that have changed, which were not made retroactive. So as a result, the Department of Justice has initiated a clemency commutations initiative to try to capture some of those cases that are just languishing and might not ever see the light of day, where the law might have changed, where someone might have been in prison for a very, very long time, where they might, have a good institutional record. Let us see those cases again. Bring them to the Department of Justice, and we'll see if the president might be inclined to shorten their sentences through commutation. I know the NACDL is one of the primary movers and shakers behind that initiative, in addition to the American Bar Association and Families Against Mandatory Minimums and federal public defenders. And of course, the American Civil Liberties Union. So we are thrilled, really, that there really might be some serious efforts coming down the pike to break through this whole mass incarceration, which has been the modus operandi over the past half century.
And it sounds like you think that this Clemency Project 2014, we're here at NACDL, it's being headed by Cynthia Roseberry, and we're spearheading, trying to turn back things, to make things right, give people a second chance. It sounds like that is one part of people are listening to what Attorney General Holder is saying, that we've got to change things. Have you noticed anybody else listening in terms of law enforcement, prosecutors actually listening to what he's saying and trying to change that mentality that's been going on for decades?
Well, it's my hope that that is what is happening. You know, one of the reasons why people across the spectrum are beginning to pay attention to criminal justice reform is because of these policies of the past number of decades have been very, very expensive. Okay, prisons are very, very expensive. Over-incarceration is very, very expensive, and that's why we see many of the, a lot of movement in the states to undo some of these practices of the past. That's why we see people even looking at issues of the collateral consequences of a criminal conviction. I know NACDL just came out with an excellent study dealing with that type of collateral damage, and people from all sides of the spectrum, and law enforcement included, are really looking at ways to seek to minimize the harm once people have come out of prison and are returning to society, so that they're not unfairly disadvantaged, whether it be in employment or housing or public benefits or education or the franchise. It is an uphill battle, particularly in the area of collateral consequences, because there's so many different state laws all across the board that have to be addressed.
And we're going to talk about reentry this